Hello guys, welcome back to another topic. So friends, today I am going to share with you about a very informative video on the topic of what are the essential conditions of marriage in terms of section 5 of the Hindu Marriage Act, which has to be followed by all Hindus. And this is a very important video if you are appearing in the examination of 3-year LLB course, because these are generally questions which comes in the examinations. So firstly, we see in short what are the essential conditions. So the first one is condition is it must not have any spouse alive, because the second marriage can only be confirmed by declaring the first marriage as a null and void, and the neither party is incapable of giving consent due to unsoundness of mind, though capable of giving consent is unfit for marriage and procreation of children due to mental disorder, and or suffers from any recurrent attacks of insanity. The next condition is the boy must be over 21 and the girl is over 18 years of age. Parties are not within the degree of prohibited relationship. So now what the general meaning of the degree of prohibited relationship, we have made a separate video on it, so we are not wasting time here. And the next last important is parties are not subindas to each other. What the subinda means, we have already discussed a separate video, you can get from the playlist of the Hindu law, the meaning of subindas. So firstly, we see in detail what are the basically essentials of Hindu marriage law, essential conditions for a valid Hindu marriage. So firstly, according to section 5 of the Hindu Marriage Act 1955, some of the essential conditions of Hindu marriage to be declared as valid are such as: first is monogamy. Section 5 subsection 1 of the act provides for the rule of monogamy and prohibits polygamy and polyandry. So before the 1950, if we can say, a man could marry a number of wives. Before the passing of this enactment, a man could marry with a number of wives, even if he had a wife or wives living, although this practice was always looked with disfavor. The condition laid down in this clause for a valid marriage is one of those conditions which is contravention of which would make the marriage void under section 11 of the act. Section 17 would further render the offending party liable for prosecution under section 499 and 495 of IPC, which is now replaced by BNS. So in the case of, if we see, in the case of Shrimati Yamuna Bhai Anantray versus Anantray Thiraram, in this case the Supreme Court held that the marriage becomes null and void where it is in violation of section 5 of the Hindu Marriage Act, because it becomes void ab initio and ipso facto. Void ab initio means from the very beginning it is declared as a void because it never takes place. We will see in our other video what is the meaning of void and voidable marriage, what are the differences in both of them. So it was further observed that the wife in a void marriage cannot claim maintenance under section 125 of the CRPC, which is now as declared as section 144 of the BNSS. So we can say a man whose wife is alive and his marriage is valid and subsisting at the time cannot marry with another wife, and he will be guilty of having committing the offense of bigamy if he marries another wife during the continuance of the former marriage. The same case would be applied if there is a woman in place of man, but the parties to void marriage within the purview of section 11 can contract a valid marriage. So second ground condition is sanity. Section 5 subsection 2 provides regarding sanity, which says that at the time of marriage, neither party is capable of giving a valid consent to it in consequence of unsoundness of mind, or has been suffering from any mental disorder of such a kind to such an extent as to unfit for marriage and the procreation of children. Neither party has been subject to recurrent attacks of insanity or epilepsy. Marriage solemnized in contravention of section 5 subsection 2 is not void, it is voidable under section 12 of the Hindu Marriage Act. In the case of Ajit Rai Shiva Limited versus Bai Vasumati, it was held that if the conditions in section 5 subsection 2 is not specified or fulfilled, the marriage is not a void marriage under section 11 but a voidable marriage under section 12. This is generally may be asked that in case a marriage takes place on the ground of in contravention of ground insanity, then it is void or voidable. It is declared to be as a voidable. Second, next topic, third essential is age of the parties to a marriage. Section 5 subsection 3 provides the age fixed for marriage to 21 years in case of bridegroom and 18 years in case of bride. A contravention of this clause would neither render the marriage void under section 11 nor voidable under section 12, but the party at fault will be liable to imprisonment, which may be extended to 15 days or with a fine of rupees 1000 or with both under section 18 subsection A of the Hindu Marriage Act. If this clause contravenes, it will be declared as a child marriage. So in the case of P. Venkataraman versus State, any marriage solemnized in contravention of this clause is neither voidable nor void. The only consequence being that a party at fault are liable for punishment under section 18 subsection A of the Hindu Marriage Act for breaching or contravening this clause. Next important fourth condition is beyond prohibited degree of relationship. Section 5 subsection 4 prohibits marriage between persons which are within the prohibited degree of relationship with each other. So very important case in this regard is in the case of Shakuntala Devi versus Amarnath, the Punjab High Court has held that the validity of marriage under section 5 subsection 4 is subject to customs and usages which is accepted in particularly India or in Hindu community. So it simply implies that if a marriage could have take place between two Hindus of prohibited degree by force or of customs, it is validly cannot be challenged. The last main ground is, initial condition is, parties must be beyond Sapinda relationship. So now here the word Sapinda means, one of the Sapinda in this regard Hindu law says, the word has been used basically Sapinda in two senses. Firstly, it means a relation connected through the same body, and secondly, it means the relation connected through funeral oblation of food. For example, if the bride is the offspring of any person within 5 generations inclusive on groom's father sides and 3 generations on the groom's mother sides or vice versa, they will be referred to as sapindas to each other. So in these cases, the Hindu Marriage Act of 1955 bars marriage between two Hindus. Section 5 subsection 5 prohibits marriage between persons who are sapindas to each other, and the parties to the marriage should not be sapindas, which this provision says. A Hindu marriage in contravention of this rule, this clause, is null and void under section 11, and as such a marriage is also punishable under section 18 subsection B of this act, under which the party at fault is punishable with simple imprisonment up to the period of 1 year or with fine up to rupees 1000 or with both. However, where custom or usage governing each of the parties to the marriage allows marriage between the parties, such marriage is valid. A very important case in this regard is in Bala Subramaniam versus Suruvattam case. It has been held that if a man or a woman are living under the same roof and cohabiting for a number of years, the law would raise presumption that they lived as husband and wife. In the case of M. Vijay Kumari versus K. Dava Balana, it has been held that according to section 5, marriage can be solemnized between the two Hindus, and a marriage between a Hindu man who converted as a Christian and a Christian lady in a Hindu form is not a valid marriage under section 5 of the Hindu Marriage Act. So basically these are the conditions which are to be fulfilled to declare a marriage as a valid under the Hindu Marriage Act. So these are the basic conditions which are to be keep in mind while if you are going to an examination purpose, because these are the basically sections. Section 5 governs about subsection 5, 1, 2, 3, 4, 5, and if any violation takes place, the punishment will be provided under section 18 of the Hindu Marriage Act.